Hello and welcome to the March 2018 episode of Lunch with a Lawyer. Today we're going to talk about student loans and whether or not you can discharge them in bankruptcy, how that works. And I wanted to talk about this because a lot of people call me to inquire about bankruptcy, and they have student loans, and they'll say something to the effect of, look, I know I have student loans, but I know you can't discharge them in bankruptcy. Well, that's not necessarily true. There is a mechanism whereby you can seek to have them discharged, and if you meet the requirements of the bankruptcy laws, you can have them discharged. So one of the biggest things I wanted to communicate with this episode is I want you to understand that student loans can be discharged in bankruptcy. This isn't a hopeless situation where you can never discharge them. You can. So I wanted to talk about that. It is not automatically non-dischargeable, and it is not automatically dischargeable. For example, credit card debt. Unless a creditor objects, that debt gets discharged. That's dischargeable automatically. There's automatically non-dischargeable, things like alimony or child support. No matter what you do, that's just not going to get discharged. Then there's in the middle, which is things like student loans, where they are dischargeable, but you must take some sort of action to get them discharged. You need to bring what's called an adversary proceeding. You file the bankruptcy, you list all your debt, including the student loans, and then you file what's called an adversary proceeding. It's the bankruptcy equivalent of a lawsuit within the context of your bankruptcy filing. And you're basically saying to the judge, Judge, I believe that I meet the standard to have my student loans discharged, and I want you to discharge them. You serve that adversary proceeding on the student loan lender. They can then file an answer. You then litigate that like you would any other lawsuit, and then the judge is going to make a call. Do you meet the requirements of the law or don't you with regard to the student loans? So that's the mechanism. So let's talk about what that law is, what the standard is. Well, back in the 1980s, there was a case that came out of New York, which is in the Second Federal Circuit Court, called the Brunner versus New York State Higher Education Services Corporation. And what came out of that case is the court said, all right, it's a three-prong test. You have to meet three requirements. Number one, you have to show that if you were required to make the student loan payments, you could not maintain a minimal standard of living. No matter what you do, that's not going to happen. You're never going to be able to maintain a minimal standard of living. The second prong is that this situation that you're in, this economic situation that you're in, where if you had to make the payments, you couldn't maintain a minimum standard of living, must be a persistent state of affairs. This is not a temporary economic situation. This is going to last a while. Okay, it persists for a significant portion of the repayment period of the student loans. The third prong is that you must have made a good faith effort towards repaying the loans. All right, let's talk about each of those three in terms of what they require, and so you can get an idea of whether your student loans would be dischargeable under those circumstances. Well, the first is that minimum standard of living. Well, that's a pretty high burden. And so the one bankruptcy court case talked about a certainty of hopelessness. You are just so destitute, in such bad financial shape, that you just can't go on if you have to make these payments. You're living on Social Security disability or SSI, or in a one-bedroom loft apartment, studio apartment, and you're eating ramen noodles for every meal. But basically, it's saying that no matter how much belt tightening you do, you're never going to be able to make that payment. It just isn't going to happen. So part of establishing your qualification under that requirement is setting forth what your living expenses are. What does it cost you to live? How much is your rent? How much are you paying for food? Things like that. And then the court and obviously an argument of the student loan lender, whether those expenses are really required. Do you really need them to meet this minimal standard of living? Do you really need that complete cable package? Do you really need to spend that much on entertainment? Where can you tighten the belt? Where can you trim expenses to make that student loan payment affordable? There are no luxuries or niceties that can be in your budget as part of indicating that minimum standard of living. So that has to happen. Now, that's tough. Now, sometimes I had someone call me that said they had a monthly payment on a private student loan of over $4,000. Now that's extreme. That's a huge payment, and that goes a long way towards meeting that first prong. In other words, that there's no amount of belt tightening that's going to make a $4,000 monthly payment on student loans affordable. It's just not going to happen. Now that's an extreme situation, but you get an idea. You have to balance that monthly student loan payment against how difficult it's going to be to shoehorn that into your budget, no matter how much you cut. So that's the first requirement. And this is also a tough requirement to meet if you have federal loans, because federal loans have income-driven repayment plans, and they can adjust your payment based on your income, and it can be as low as $0. Now that's adjusted every 12 months depending upon your income. As it changes, goes up, down, whatever, but it is possible to have a $0 payment. And the argument of the federal government on your action is going to be what? You can't afford $0 a month? So that makes it kind of tough to get rid of a federal student loan under these circumstances. The only argument that it can be made, and is kind of gaining traction in the courts, is that you don't really get a fresh start under our current tax code with income-driven repayment, because, and I've gone over this in other videos and things like that on what income-driven repayment is, but if you get to the end of the maximum repayment period, either 20 or 25 years, and there's still a balance due, that balance is discharged. Now, under our current tax codes, that is a forgiven debt, and the amount that is forgiven is considered taxable income by the IRS. So the argument to bankruptcy courts has been, what kind of a fresh start is that? Yes, right now it's okay, because there's zero payments, but then they get presented with a tax bill 20 to 25 years down the road, which could be huge. So have they really gotten a fresh start? So we'll have to see where that goes, but you can see what the difficulty is in meeting that requirement. The second is a persistent state of affairs. How long do you expect this to happen? Is this just temporary, or is this long-term? Now, one thing that is looked at on this persistent state of affairs is, well, what's your current employment? Let's say you got they look at your degree. Well, what were you trained to do? What was your degree in? And are there jobs in your field? And what is the income, the average income of those jobs should you obtain them? So you say, well, the job market isn't good in my field. Lawyers ran into this to a great extent with the job market for lawyers, and where they may be able to get some of these higher paying jobs that might allow them to afford their student loan payment, but the jobs weren't there. Well, is that going to last forever? Is that a persistent state of affairs? Is the lawyer job market going to be terrible for a long time? Well, it may not be. And then, if you are employed in your field, is the reasonable income for that field such that you can afford to make those payments under that employment, under that income, or is it simply unaffordable? And one of the concerns is that people that often seek discharge are underemployed. There was one case where the court stated where you had someone who previously worked as a salesman and an audio engineer at a much higher income. And the court said the debtor's choice to work as a pastor in a small startup church can't excuse his failure to supplement his income so that he can meet knowingly and voluntarily incurred financial obligations. By education and experience, he qualifies for higher paying work and is obligated to seek work that would allow debt repayment before he can claim undue hardship. So you can't say, well, I trained for this field, it's a lucrative field, and I can make a good living at it and the jobs are available, but you know what, I got out of school and I really don't want to do that anymore. I just want to do this, and whatever this is at a lower income level. Well, that's really not going to meet that test. So that can be difficult. And have you, another thing to look at is, have you earned more money in the past? There's another case where the debtor was over 40, was a single parent of a 7-year-old, and was self-employed as a decorative painter. She had an associate's degree in tourism as well as a real estate license, and in the past she had higher paying jobs, restaurant manager, that sort of thing. The court in that case ruled against her dischargeability, noting that having a low-paying job does not in itself provide undue hardship, especially where the debtor is satisfied with the job, has not actively sought higher-paying employment, and has earned a larger income in previous jobs. So this is, as you can see, a real case-by-case basis on whether you can meet that. Is this something that you'll ever be able to afford? So as you can see, it can be a difficult burden in doing that, because if you have the potential to make more money, but you're not, even if it isn't working in your field, if your education gives you the ability to work in a more lucrative field that'll give you more income, you have the obligation to do that. So you can't just sit in your current situation, do nothing to try and improve your income situation with a better job, and expect to get a discharge under this test. The third is, has there been a good faith effort to repay the loan? Have you made any efforts to try and do that? If you have a federal loan, have you applied for income-driven repayment? Have you tried any of that? Have you made, how much payments have you made? Have you paid anything on the loan? And they compare how much you paid to the overall balance on the loan. Have you paid a significant portion of it, made efforts to repay in that regard? And they also look at whether the student loan was a significant portion of the overall debt in the bankruptcy. So to say, well, if you're able to discharge other debt and that frees up some money to pay your student loans, then that may be a situation. But if your financial situation is entirely that of your student loans, that's a whole other situation. So that's the three-part test. And most of the federal circuits in this country adopt that test, the Brunner test. And what's happened is, Brunner test, as I said, was out in New York in the Second Circuit. And then other circuits have adopted it and said, you know what, that's a good idea. We're going to use that standard. In the Third Circuit, where we are here in New Jersey, the case is in re Faish, F-A-I-S-H, and that officially adopted the Brunner standard. So that is what you need to meet. Now, a lot of cases, it's easy to say, well, yeah, I think I meet that standard. The problem is, not a lot of these cases get litigated, and the reason for that is the expense. All right, bankruptcy attorneys will do a straight bankruptcy for a flat fee. They know what it is. It's all very straightforward. They have systems in place to handle it, and they can do that. So they'll charge a flat fee. But as I said, with student loans and they get them discharged, you need to bring an adversary proceeding. And attorneys will charge an hourly fee for that. And they'll want a retainer. And for example, I charge an initial retainer of anywhere between $7,000 and $10,000, depending on the facts of the case how straightforward it is, whether we need economic experts, things like that. So it can be expensive, and then you charge at that hourly rate, whatever the hourly rate is, and that can really rack it up. And the fees are payable whether you win or lose, okay? So you need to look carefully at how much you're looking to discharge. How much do you have in student loan debt? Is it $15,000 or $20,000? Is it $90,000, $100,000, $125,000? Where an investment of money in attorney's fees to seek a discharge is worth the amount of debt that you think you can wipe out, depending on what your chances are, and you've consulted with an attorney to see whether the facts of your case fit within that Brunner test. So as I said, it don't really only make sense with the higher balance private loans because it's difficult, as I said, because of income-driven repayment to discharge a federal loan, although that tax argument is starting to gain traction in the courts. But you can also sometimes, you may not be able to discharge all the debt, but the lenders may agree to discharge some of it. So you may start out $125,000, for example, in total student loan debt. You negotiate with the lenders, and maybe you can drop that down to maybe around $50,000. So you've cut it more in half on the principal amount, and that correspondingly significantly reduces your monthly payment to make it more affordable. So a home run's always good, but sometimes a double or a triple can work for you as well with these partial settlements. But you need to check. Some judges are all or nothing. Some of them will say, yes, I'll discharge some of it. Others saying, no, it's either all dischargeable or it's not dischargeable. So you need to see, and you won't know who your judge is until you file the case, although depending upon where you are, and again, we're dealing here in New Jersey with what vicinage you're in. Are you in Camden, Trenton, or Newark? Who are the judges there? Do any of the judges allow for partial discharges? So that's something to look at as well. Now, you may ask yourself, well, why do we have this test? Well, as I said initially, this came out of a case in the 1980s. And the laws, the situation with student loans are very different back in the 1980s. And the bankruptcy code was very different in the 1980s. Basically, the non-dischargeability applied to guaranteed student loans, government-backed student loans, not private loans. Private loans only gained that protection in 2005 with the changes made then. So back then in the 80s when this case came about, if you had had a guaranteed student loan for more than 5 years and you filed bankruptcy after that 5 years are up, you can get them discharged. And that was it. Okay, no adversary proceeding, no nothing. But if you brought it within that 5-year period of time, then the Brunner standard, the Brunner test came into place. Now, that 5 years got extended to 7, and then later that time was eliminated altogether and said there is no minimum period of time. You always have to meet the Brunner test. All right, not within 5 years, within 7 years, but anytime. And then in 2005, they gave this protection to private student loans as well. So in that context, you can see why the test is so tough and why you have the 3-part test. Let's say back in the 80s, you've got that 5-year period of time, you graduated college, you're having a difficult time finding a job, you have other credit card debt, things like that, and you want to file bankruptcy and you're within the 5 years. Well, it's no, wait a minute now. Like I said, is there any ability to repay it, the minimal standard of living? And you can see where the persistent state of affairs makes sense. Is this going to last for a while? Okay. Can you tough it out for the 5 years, for the 7 years, and make third prong a good faith effort to repay the debt and to repay the loan? At least try. Okay. Don't just throw in the towel within that 5 years, file bankruptcy, and expect that it'll be discharged. They're going to hold you to account. They're going to hold your feet to the fire. Have you really tried to get a job? Have you really tried to get a job within your field? Have you really tried to get a higher paying job? What have you done? Is this a temporary situation? You're taking advantage of the fact that you don't have a job right now? Or is it a persistent state of affairs? And can you make the money you need to pay it? So it makes sense in that context, but the laws have changed. So you're talking about a standard that is almost 40 years old. That really doesn't apply anymore, that needs to be re-examined, but that hasn't happened, at least not in the Third Circuit. So you're dealing with an old test, and you're struggling with that, but private student loans, and one of the advantages they have is private student loans don't have a lot of times income-driven repayment or some of the administrative discharge options or things that you have with the federal program. So say, gee whiz, if this was a federal program with income-driven repayment, maybe I'd be able to afford it, but they want $4,000 a month or $2,500 a month or whatever it is, which could be quite burdensome. So that is where we are with student loans in bankruptcy. Now, I do want to caution you that, and as you can see from my description of the three-part test, this is a highly fact-driven situation. Every case is different. All right, they applied the test. Well, what facts are you applying to that three-part test? So please, I'm doing this to educate you on what the test is and what you need to look at in your situation so that you have a better idea of whether you would meet that test. But please, this video is not intended to replace a consultation with a bankruptcy attorney who can look at your case, your set of facts, and determine whether you have a shot at a discharge under the Brunner standard. So this is not legal advice. This is not a consultation with an attorney. Sorry for the disclaimers. I am a lawyer. I got to do that. But I also want to be fair with you that you shouldn't rely on this too much. This is educational. This gives you a good idea going in. So maybe you're a little better prepared to meet with that bankruptcy attorney to give him or her the information they need to give you a good opinion. So if you think that you might meet that standard and you have student loans you really need to deal with, then definitely talk to a bankruptcy attorney. You might also want to talk to a student loan attorney on how to deal with that, because there may be some non-bankruptcy options available to you to deal with these student loans. There may be another solution other than the bankruptcy. If you're looking for a good student loan lawyer, I would recommend you go to the website thestudentloanlawyer.com. You can then click on a map of your state, state of New Jersey, for example, and it will list the practicing and trained student loan lawyers in your state. And you can try and find one near you and talk to them. So bankruptcy attorney, certainly, and there may be some other debts and situations you need to deal with in discharge and bankruptcy, but also get a good student loan solution. It may not be bankruptcy. There may be another solution for you that would be a lot less expensive than the thousands of dollars for an adversary proceeding to try and discharge those student loans in bankruptcy. So that's it for this episode of Lunch with a Lawyer. If you liked this video, please click the thumbs up button. Please like it. If you love it, please love it. It helps with the search results. And also share it. Now, I realize we're talking about dischargeability of student loans in bankruptcy. So you might want to share this on your friend's timeline, all right? But you can share it on Facebook in Messenger. And that, you're just showing it to that person in their Messenger. And say, hey, look, on the side. You might want to watch this video. It might help you out. So you don't have to share it on their timeline. Or just share it publicly. It's that sort of sensitive topic. So if you feel comfortable sharing it, just share it. If you feel you want to be discreet or recommend it to a friend or two, you can do that through Messenger. This video will also be posted on my YouTube channel at richardsonlawoffices.tv, usually within a week. So sometime next week you'll see this in the feed. So you can certainly watch it then. If you like the YouTube video, hit that thumbs up button on YouTube. Share it if you'd like to share it. And even more so, if you like the content on the channel, I release videos all the time to my YouTube channel. Just hit that subscribe button and get some great content, great video content on various legal topics here in New Jersey. So that's it for Lunch with a Lawyer, and I will see you next month.